Hi friend, welcome to the Company Law Adjudication and Appeal Series. Today we are discussing Southeast Region Regional Director Appellant Order against the Karnataka ROC order imposing penalty on the company for non-disclosure of the Constitution of Internal Complaint Committee under Sexual Harassment of Women at Workplace Prevention Prohibition Redressal Act 2013. Karnataka ROC, in his order of adjudication, stated that during the course of inquiry under Section 206, subsection 4 of the Act, it noticed that board report attached to the financial statement for the financial year 2018-19 and 2019-20 did not disclose that the company has complied the provision relating to the Constitution of Internal Complaint Committee under Sexual Harassment Act. Hence, the company has violated the provision of Section 134, subsection 3 of the Companies Act, and company and officer in default of the company are liable to action under Section 134, subsection 8 of the Act. Accordingly, hearing was held before the ROC, and after hearing, the authorized representative levied penalties as on the company. There is the 3 lakh for the 1 year and 3 lakh for another year. This is the default of the 2 year. That is the total penalty imposed on the company is 6 lakh, and 50,000 on the managing director, and 50,000 on the CFO, and 50,000 on the company secretary. And hence there is a 2-year default. That is the double the penalty amount. The total penalty imposed is the 9 lakh. Accordingly, an opportunity of being heard was given to the appellant. The authorized representative appear on behalf of the appellant and give submission in the appeal and submitted. This point is important. The company has always created a safe and harassment-free workplace for every individual working in the premises, including sexual harassment. Since the company has less than 10 employees in each of the establishment, it is not required to constitute an internal complaint committee as per the Section 6 of the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. Second submission, that non-disclosure of the statement in the board report for the financial year ending 2019 and financial year ending 2020 relating to the constitution of the Internal Complaint Committee was not a deliberate act, since the company is not required to constitute a internal complaint committee under sexual harassment of women at workplace prevention, prohibition and redressal act. The disclosure with respect to the constitution of the committee as required under the law is not applicable and not made in the board report. However, the same is mentioned in the board report in the succeeding years. And third submission, that company has complied with the provision relating to the constitution of the Internal Complaint Committee. Also, during the year of the default, there were no women employees in the company. Hence, guidelines as specified in the Visakha versus State of Rajasthan mention only with the regard to the constitution of the Internal Complaint Committee. The company has duly complied with the guidelines as specified by the Honorable Supreme Court. And fourth submission, that company would like to comply with the law in letter and spirit. In light of the foregoing, the company requests to take a merciful view of the said matter and to permit appeal of the offence which was committed unintentionally, and to levy a reasonable monetary penalty with respect to the same. Though there is a default committed, there is a ground in interfering with the adjudication order of the ROC to the extent of reducing the quantum of penalty, and taking into the consideration of the facts of the appeal and submission made by the authorized representative. Here, reducing ROC penalty to 20% of the total penalty imposed by the ROC. Here, on the company, 60,000 for financial year 2019 and double for the second and this penalty for the 2 years. That's why this is the 6 lakhs to 1,20,000 and 1 lakh to 20,000 on the managing director, CFO and company secretary. That's the total penalty imposed here is the reduce here is 1,80,000 from 9 lakhs. And accordingly, the penalty was paid by the company and officer as given in the table. Accordingly, this order is issued to the appellant with the copy of the to ROC Karnataka. Thank you so much for watching this update. This order is pronounced on 13th December 2023.